Court has cleared the path for 10% EWS quota, that is 10% reservation, a maximum of 10% reservation for the economically weaker sections in education as well as public employment. Now, there were 5 judges on this bench. 3 felt that the EWS quota is constitutionally valid, so they formed the majority, of course, while the 2 in the minority felt that it needed to be struck down. And interestingly, Chief Justice of India UU Lalit is in the minority here. He dissented with Justice Ravindra Bhatt. But what does this quota mean and what did the judges actually rule? I'll tell you in this episode of KYC or Know Your Constitution. Now, briefly, just to give you a background of this reservation, this quota was introduced by the 103rd Constitutional Amendment in 2019. So, this was introduced by introducing provisions to the Constitution. It provides for a 10% reservation in government jobs and educational institutions for the EWS category. To do this, it amended Articles 15 and 16 of the Constitution. You can see both of these articles on your screen right now. Now, Article 15, as we see, bars discrimination on the grounds of religion, race, caste, sex, or place of birth. And Article 16 guarantees equal opportunity in matters of public employment. Subclause 4 of both these articles allows the state to make special provisions, and it is under these provisions that the state and the governments have provided for reservations for SCs, STs, OBCs in public employment as well as education under Articles 15 and 16 of the Constitution. Now, the 2019 amendment added a clause to both of these articles, Clause 6, allowing the Parliament to make special laws for the EWS category, similar to what it does for SCs, STs and OBCs. And this 10% reservation will be in addition to the existing reservations. But of course, 40 petitions were filed in 2019 raising legal questions on the validity of the amendment. Now, this reservation was challenged on various grounds. I'll be focusing on a few of these grounds in this video. Firstly, the petitioners alleged that the quota violates the basic structure of the Constitution. Now, we've told you about basic structure before. There's no set list of what constitutes the basic structure. For example, over years, federalism, secularism, equality, rule of law, all held to be a part of the basic structure, but courts have, of course, devised a few principles. Now, the majority in this 5-judge bench was Justices Dinesh Maheshwari, Bela Trivedi and J.V. Pardiwala, who ruled that the quota does not violate the basic structure of the Constitution. The court also looked into whether the amendment violates the Supreme Court's 1992 judgment in Indira Sawhney versus Union of India. This was a landmark case, also known as the Mandal Commission judgment. In that judgment, the Supreme Court had capped reservations at 50%. So, there's basically a 50% ceiling on reservations, and had also said that economic backwardness cannot be the sole criteria for recognizing a section of people as a backward class. On this point, the majority judgment said that a reservation structured singularly on economic criteria, that means just on economic criteria, does not violate the basic structure of the Constitution. And they also ruled that breach of 50% limit by EWS reservation does not violate basic structure. Essentially means that now when EWS quota is added to the other quotas in jobs and educational institutions, it would well be above 50% out of the total. In her judgment, as parting remarks, Justice Bela Trivedi, who also formed a part of the majority, said that there's a need to revisit the system of reservation after 75 years of independence. Justice Pardiwala also said that reservation cannot go on for an indefinite period so as to become a vested interest. Now, as against this, the dissent authored by Justice Bhatt said that reservation on economic criteria is per se not violative. So, on that point, the dissent did agree with the majority verdict, but it said that this reservation only on economic criteria is per se not violative if it's made under Article 15 and not Article 16. But in any case, they pointed out that this reservation, that is EWS reservation, it expressly excludes SCs, STs and OBCs. So these provisions that were added to Articles 15 and 16, what they said is that this reservation would be, I'm paraphrasing of course, you can see these provisions on your screen right now, but it uses the words other than. So it said that this reservation can be made for those people belonging to the EWS category other than those who are already getting the benefits under Articles 15 and 16. Essentially what this does is it takes away the benefit of this quota from SCs, STs and OBCs. There are various reasons given for this. One of the reasons being that they already have benefits. So there was then this whole argument of double benefits also given. But the court said that this essentially means that this quota practices constitutionally prohibited forms of discrimination. The court said that making this divide between the poor within the EWS category and excluding the SCs, STs, and OBCs from this reservation itself constitutes a form of discrimination. The dissenting opinions pointed out that this amendment is deluding us to believe that those getting social and backward class benefits are somehow better placed, but they explain that these benefits that SCs, ST, or OBC communities are getting, they're not a free pass. These benefits are compensatory mechanisms for their reparation, for the historical wrongs that were done to them. So this is what the dissenting opinion said. It's the main crux of the argument of the dissenting opinion was that while especially under Article 15, economic criteria could form the basis for such a reservation, in this particular case, because this EWS quota forms a classification and excludes SCs, STs, and OBCs from their purview, therefore it violates the basic structure of the Constitution. Now, the dissenting opinion also ruled against the breach of the 50% ceiling. They didn't go into this question in too much detail because the first question itself was answered in the positive. But they did say that if this is allowed, if governments are allowed to breach the 50% ceiling and cap on reservations, the rule of right to equality will become right to reservations. But of course, this is just the minority opinion. Since the majority opinion has upheld the amendment and the quota, the path is now clear for this reservation to apply in educational institutions and government jobs, unless there are more challenges to this in the Supreme Court or before larger benches, or unless a review petition is filed. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.